William and Mary law professor Jonathan Adler explains why the pace of judicial appointments has fallen under the new Trump administration and what it means for gun policy. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of the Reload.com, where you can head over and sign up for our free weekly newsletter if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis. This week, we are talking about, the situation with the federal court system. Taking a macro view of what's going on so far in President Donald Trump's second term, and more on the, rather than the details of rulings or anything like that, more on the appointments side of things. And to do that, we have with us a great writer and William Mary Law School professor, Jonathan Adler, to talk about the situation. Welcome back to the show, Jonathan. Thank you so much for joining us.
Good to be here.
And just tell people a little bit more about your background before we get rolling.
Sure. So I'm a law professor. I've been doing that for 25 years now. For most of that time, I was at the Case Western Reserve University School of Law in Ohio. I have now returned to Virginia, where I am now the Tazewell Taylor Professor of Law at William and Mary. Most of my work concerns administrative law, regulatory policy, things of that nature. But I've long done work as well on kind of the judiciary, judicial nominations, court operations, court interactions, and things like that. And so have been following and writing about judicial nominations for most of the last few decades.
Yes, and you have a new piece over at the Volokh Conspiracy at Reason Magazine where you discuss some of this, and I wanted to bring you on and just have a more in-depth conversation about what's going on with the federal judiciary. Here we are, 6 months into the new administration, 7 months into the new administration. And because I thought it was interesting, it seems like there's been perhaps less movement there than most people would expect. What's the state of things, right?
Well, that's definitely the state of things. I mean, for a new administration, there have been fewer vacancies on the federal courts for the president to fill, and there have been fewer nominations and fewer confirmations. So if we compare this to the first 6 months of the Biden administration, the first Trump administration, the Obama administration, George W. Bush administration, you see fewer vacancies, fewer appointments. There's often a decent number of appointments available at the beginning of a president's term, especially when you have a change in political parties. One reason for that, obviously, being that some number of judges are more willing to step down or take senior status and create a vacancy when a president is in office who is of the same party as the president that appointed them. And we don't see the same uptick that we would normally see. And we also seem to be seeing judges caring about that more than they perhaps used to. So the number of vacancies created by judges appointed by a president of the opposite party also is smaller than we would have seen or we saw at the beginning of prior administrations. So overall, fewer seats to fill. And the administration has also not been as quick as it had been in prior, or it's in the first term, or as some prior administrations had been, to name nominees. And my view has always been that, while when you have Senate control, everyone says they're going to prioritize, the leadership always says they're going to prioritize judicial confirmations. But in reality, if you want there to be steady progress in confirming judges, you also need to make sure that the pipeline is full, right? There needs to be pressure in the system so that judges are sufficiently prioritized. And So fewer vacancies, fewer appointments, less pressure in the system. So the Senate, not as much pressure on the Senate to act. And at this point, it does not look like the second Trump administration will have anywhere near the impact on the federal judiciary that the first Trump administration did, and that's even setting aside the question of the Supreme Court, because obviously that's a category by itself, right? The first Trump administration had 3 appointments to the Supreme Court in a single term. Haven't seen something like that in 50 years. So set that aside. It is unlikely that this term is going to approach the first term in terms of impact on the federal judiciary.
And just to give some numbers from your piece, this is from Russell Wheeler at the Brookings Institution. And I think he said to this point through July, at least, there had been 21 vacancies created since Election Day for the second Trump term. That compares to 67 for Joe Biden, 45 for the first Trump term, 46 for the first Obama term, and 36 for the first George Bush term. And so that's pretty stark, right?
Yes.
It's a pretty stark drop off, especially from, compared to Biden.
Yeah, no, it's a big drop off. And, obviously Democratic appointed judges that have been much less likely to take senior status or retire than we would have seen, or we've seen under prior administrations. But you see fewer among Republican appointed judges as well. And, that's significant because there are a decent number of judges who were appointed by Republican presidents who are eligible to retire or take senior status. They haven't done so. And, we can speculate as to why that is.
And I do want to speculate on it, but just to give some numbers real quick.
Yeah, go ahead.
Just looking at this same chart from your piece from the Brookings Institution, it looks like through July there have been 18 Republican appointed federal judges who've taken taken senior status or retired to create a vacancy. That compares to 29 in Trump's first term, and only 3 Democratic appointed judges have done the same, compared to 16 through July during Trump's first term. So, yeah, pretty substantial shrinking from both parties, at least at both judges who are appointed by both parties here. But yeah, definitely more so, I would say, from the Democratic appointees. And that is, it's certainly unusual compared to the numbers that he has for Obama, Bush, and Biden, where they were all, Bush only had 7. So, from Democratic appointed judges who created vacancies, but, Obama had 12 Republican ones and Biden had 19. And again, Trump, the first one, had 16. So seems like there's been a pretty significant shift from those previous years to now.
There has been. And, in terms of thinking about, policy, whether it's gun policy, other sorts of things, where we tend to care the most about this is with regard to the circuit court judges, right? So these are the appeals court judges. We care more about them for a couple of reasons. One, there tends to be less influence of the Senate delegation on who those nominees are. So, in a state where you have 2 Democratic senators and a Republican president, there is going to be negotiation over how those seats are filled. Those aren't really the White House's picks, or exclusively the White House's picks. But circuit court judges are where the White House tends to have more direct influence. That's certainly been the case in the 21st century. Also, those are the appeals courts that are making rulings on pure questions of law. Really not, they're not holding trials. They're dealing with the broader legal questions. And so, when it's things like, applying the Second Amendment or applying administrative law doctrines and things like that, those appointments matter. And when you look at circuit court judges, there are, I think, currently 4 circuit court vacancies, current or future vacancies. They have nominees pending. That's it. There are about 40 judges on the circuit courts of appeal who are eligible to take senior status right now. And the majority of those were appointed by Republican president. By my count, 14 of the 40 were appointed by Democratic presidents. The other 26 were appointed by Republican presidents. And so those are the judges we would most expect to be taking senior status or retiring and thereby creating a vacancy. And they haven't. And that means that there aren't a lot of circuit court vacancies to fill, and it means that the balance of the circuit courts, which matters in a way that, we can talk about the balance of district courts, but since at the district court level, it's one judge hearing a particular case at a time. On the circuit courts, it's 3-judge panels, so the balance of the circuit matters for the composition of those panels, and then it also matters for en banc decisions when those circuit courts sit as a whole to deal with a particularly contentious question. And the likelihood that the Trump administration is going to flip any of the circuit courts, looks less likely because we don't see where a lot of those circuit court vacancies are going to come from if judges that are eligible now are not likely to or don't take senior status or retire. Now, there are a couple that have been eligible for a little while that we might see retire later this year, so that they can be replaced before there's a risk of the Senate switching hands.
Right.
But I don't.
That's another aspect we need to talk about too.
I think that I think that we would. We're not going to see a lot of circuit court vacancies created. There aren't a lot of judges that aren't yet eligible that will become eligible this calendar year. I think there's a total of 3. 1 Republican appointee, 2 Democratic appointees that will become eligible later in 2025. It's not entirely clear where a lot of, if judges that are eligible now are not taking senior status, it's not entirely clear where those vacancies are going to come from.
That's interesting. So we can already have a pretty good feel for where things are headed, even just in August of 2025.
A decent feel. Like I said, there are a handful of judges. I'm reluctant to name names in case a judge or one of their clerks or something is listening. But there are a handful of judges. There's one on the Second Circuit, one on the 10th, here and there that you might expect to take senior status, between over the next 6 months or 8 months, so that there's not a risk of the Senate changing hands. But we're talking small numbers. And if you look at the circuit courts, there are Republican majorities on 5 of the circuit courts. There are Democratic majorities on 7, and there's one court, the Third Circuit Court of Appeals, that's evenly split. And there is there's a nominee that's been announced, but that just a little bit of technical speak in case people hear this stuff. Technically, for a nominee to be pending, their paperwork has to actually have been submitted to the Senate. It is common for a president to announce a nominee before that paperwork is ready, and sometimes there might even be a couple weeks. So we know that a woman named Jennifer Mascott, who's professor at Catholic University, law professor at Catholic University, and someone who worked in the White House counsel's office in the Trump administration and clerked for Justice Thomas and then Judge Kavanaugh, it has been announced that she will be nominated to the U.S. Court of Appeals for the Third Circuit, but it's not officially pending yet. But so, assuming she is confirmed, the Third Circuit will have a 1-judge Republican appointee majority.
How many appeals court judges, how many circuit court judges has Trump actually gotten confirmed to this point?
This term, 2. So Whitney Hermendorfer for the U.S. Court of Appeals for the Sixth Circuit, who was his first nominee, and then Emil Bove, who was confirmed to the Third Circuit, who obviously It's one of the more controversial judicial nominations we've seen.
Yes, and that's actually what I wanted to get into, because Emil Bove is maybe an example of part of the reason this could be happening.
Well, so we've hypothesized on that. I mean, so right, it's worth remembering, right? Donald Trump is not, or was not when he ran for president the first time, kind of part of the Republican establishment, part of what we normally think of as or what a Republican nominee would have been like. And there was a lot of uncertainty about what that would mean for certain issues that are very important to certain Republican constituencies. In the first Trump administration, where there had been a lot of question about what sort of judges he would nominate, I think the general consensus is both that that he nominated the sorts of judges that you would tend to expect in a Republican presidency, and then some. That is to say, the overall quality and caliber of his nominees from a conservative perspective was, the greatest that we've seen in my lifetime. I think by a lot of objective measures in terms of the qualifications, intellectual firepower, and the like. You had not seen a president or a presidential administration that focused on nominating judges, especially appellate court judges, that would affect the law as much as occurred in the first Trump administration.
But he kind of let a lot of that fall to the conservative Federalist Society.
Well, yeah, I mean, so Don McGahn, who was the White House counsel in the first Trump administration, as he put it, it's not that they outsourced judicial appointments to the Federalist Society, it's that they insourced the Federalist Society into the White House counsel's office. And so, but there was a lot of attention to the intellectual firepower of judges, the commitment and understanding to jurisprudential principles. And there have been subsequent studies done by some academics and some others looking at the effect, and you actually, you certainly see evidence that Trump nominees write more, they're cited more by other judges. I mean, that they have been more influential and impactful, that you can really identify a critical mass of judges that are thought leaders that are really affecting. They're more than just a vote on a panel, that they're actually influencing the nature of the discussion about various legal issues and having a big impact.
And they, by and large, took a originalist view of the Second Amendment as well.
Originalist judges in terms of their view of the Second Amendment, their view of the Constitution, textualist in terms of their views of statutes, fairly formalist in their views toward legal rules and how you think about applying legal rules. And really kind of put there was kind of it affected not just the numbers and balance of individual courts, but it really affected the way cases are argued, the way judges think and talk about various questions. And I think that's very significant. There was some question about whether or not the second Trump administration would follow suit, in part because a lot of people close to the administration had made comments about Federalist Society judges not being sufficiently MAGA or having courage or what have you. I tend to think from a jurisprudential standpoint, I tend to think those criticisms really don't mean much. But there were cases in which Trump nominees or other conservative justices or judges did not vote in the interests of the Trump administration. There are some that think that's the way you should evaluate a judge, as opposed to
more based on adherence to loyalty to the president. Yeah,
and we've gotten a mixed signal on that in this term. So in the first administration, there were certainly judges that were concerned about, okay, what kind of people is Trump going to appoint? And we saw, especially early in the Trump administration, a lot of appointments to a lot of positions where it was like, where are these coming from? But not for judges. In this administration, the first two appellate nominees really pointed arguably in two different directions. Whitney Hermendorfer, the first appellate nominee this term to the U.S. Court of Appeals for the Sixth Circuit, very much in line with what we saw in the first term. Very solid conservative credentials, had worked in the Tennessee State Attorney General's office as the Solicitor General or Deputy Solicitor General, had been involved in a lot of impact litigation, had clerkships with conservative justices and the like. And then the second nomination was Emil Bove to the U.S. Court of Appeals for the Third Circuit, who may well be a fine lawyer, may well have been the sort of person we might have expected to be a judicial nominee in, say, the late 20th century, when a decent number of judicial nominees were patronage picks, were friends of the president or friends of the president's friends, and so on. I mean, that was a decent proportion of judges that had been more of the practice then than it has been the last 20, 30 years. The old joke was, a judge is, someone that plays golf with a senator. But there were certainly concerns about both the combination of kind of the lack of evidence or experience that suggested much of a jurisprudential commitment or her core, right? So both in terms of writings, in terms of work and so on, not something that made people comfortable about what sort of judicial philosophy he might have. And then things that suggested why he was picked, which is, having represented Donald Trump as an attorney, and then having been, at least by some accounts, something of a hatchet man within the Justice Department to do the president's bidding, not on principled legal basis, but on the administration. Now, I should just say, I'm cautious the way I put it, because I am not sure how much confidence I have in the various reports about what did or did not occur, and what Emil Bove in particular was responsible for. I think the allegations are disturbing.
Right, because he was accused essentially of telling Justice Department employees to disregard court.
There are things that we know for sure that I think are somewhat disturbing. Then there's some things that are arguably worse that where I'm not entirely sure. And
some of those things are just allegations
on the Supreme Court, and the way Supreme Court commentary goes. When the level of accusations go up, my skepticism tends to go up as well. But certainly, he was involved in putting pressure on New York Mayor Eric Adams by agreeing to drop charges against him in return for political support of and favoritism to the administration. And the way that was done looked really gross, looked really inappropriate, right? That seeking to have the charges dismissed with prejudice in return for his agreeing to do policy things, to use his power as mayor to support Trump administration priorities. And we know Emil Bove was involved with that. And that certainly looked pretty gross. And then again, there were these allegations that he encouraged or called for disregarding court orders internally. We don't know as much about that.
Right. Several whistleblower complaints accused him of telling lawyers to disregard court orders, which, when that's the person that is nominated to be a judge, you can start to see why. Again, as you correctly noted, these are allegations and we don't have hard evidence it's true, but there were several people who accused him of this. And so I guess the idea here is if you put up somebody like Bove with that kind of track record and the controversy surrounding him, maybe it's turning off some of these judges from making vacancies for you to put up other nominees.
Because if a judge says, well, I want to be replaced by someone who respects the rule of law, who has judicial temperament, increasingly increasingly in the last few decades, who generally shares my judicial philosophy, who would generally make the sort of rulings that I would make. There are a decent number of judges that will look at that nomination and say, well, I don't know what his judicial philosophy is. I don't know. I have reasons to worry about his respect for the rule of law and his view towards the judicial system. So is that really the sort of person that I want to replace me? Now, to be fair, the appellate nominees that the president has announced or made since that nomination have reverted back to form in terms of folks that are, have the sort of track record and credentials and so on that would I think, give judges greater comfort. I mentioned Jennifer Mascott. I'm now going to blank on the. There's one for the Seventh Circuit to replace Diane Sykes, who I should remember because her father was a professor of mine in law school and a very solid nominee for the First Circuit in Maine, and then Eric Tung for the Ninth Circuit. These are all, these nominees are all kind of what you would normally, I think, expect, what a judicial conservative would want to see. The biggest criticism one would make is that, as has been the trend for circuit court nominees, moving more towards the younger side so that the judges will serve longer or are able to serve longer. But this mixed message, right? For judges that are deciding, do I want to step down? This is something that we have reason to think at least affects the way some of them think about this question. I've certainly heard that said by judges, that it influences the way they think about it. Now, to be fair, there are some judges out there who just genuinely think they are irreplaceable. We should remember Justice Ginsburg did not step down despite her age, and then died and was replaced by President Trump, which certainly was not what she had intended.
Changed the balance of the court, yeah.
But we know of judges where that happens, where current judges where the same thing is happening, but that's not all.
But Kennedy is perhaps a good example of what you're describing here, with wanting to make sure that his successor was somebody he approved of, right? I mean, it seemed like that was part of the deal for when he decided to retire.
It looks that way, and we do know of judges, a handful of judges that effectively named their replacements, and we even know of a judge on the U.S. Court of Appeals for the Fourth Circuit who rescinded his announcement that he was going to go senior when he was not replaced before Biden left office.
Interesting.
Which
I didn't know you could do that. So that's
I mean, not clear. You should be able to do that. I'm not sure it's appropriate, but it happened. He's still on the bench, and I should say, as a matter of judicial ethics, I'm not a fan of a quid pro quo to retire, but
right. It's obvious problems with it, but yeah.
But it has we know it has happened, and I don't think it's unfair to suggest that the current administration might even be open to that. And then, as happened with Justice Kennedy, there are ways to kind of send signals about, hey, look, these are the sorts of people we're thinking about. This is the sort of thing we're looking at,
right. Which perhaps is what could happen here. Like you said, I mean, if Bove turns out to be an anomaly in the way that the second Trump administration is, nominating judges, maybe more of these judges, especially the Republican appointed ones, will start to open up to the idea of going senior or retiring.
It's certainly possible. I mean, one thing we should add to the mix is, during the Trump administration, and we saw some of this in the Bush administration, of judicial nominees getting younger. And the formula for being eligible to retire or take senior status is a function of age plus years of service. So it's you need it's years of judicial service plus years past the age of 65. And so the younger you are when you join the federal judiciary, the younger you can be and be eligible for senior status. And so, there are people that are eligible now who are, 66, 67, 68. There are, certainly a decent number that are between the ages of 70 and 75 who, we don't really think of that being that old for a judge. And, the numbers that are in their late 80s, there is one who is 98, but she is the outlier. We don't see a lot of those, and so it's certainly true that one thing that may be having an effect over time is that as people become eligible for senior status at an earlier age, they hold on for longer, and that may affect the rate of vacancies as well.
So, obviously the juicier bit is the political considerations, but there are non-political reasons why this is likely happening, which includes just judges are living longer, they're being appointed younger, they have more years eligible to take senior status when they may not feel ready to do that. And, it kind of reminds me a bit of a passage in Jake Tapper's book about Joe Biden, where, the whole people trying to hang on to political authority in DC is not something that's new, right? It's very difficult for somebody oftentimes in a position of power to walk away from that, even if they should. And so I think people hang on as long as they feel like they can, and maybe oftentimes even past when they should. But here you have, as you're describing, a dynamic as well where it is politically beneficial to appoint younger judges, the younger and younger ones, because it's a lifetime appointment. And so the younger they are, the longer they can serve. And then that runs up against the incentive to just want to stay in your role when you've reached something like a federal judgeship. That's going to be the crowning achievement of most people's most judges' lives and most people in the legal profession, and they're not going to want to walk away, even if even if it helps out the president from the party that appointed them or whatever. They still may not want to do it, and then that's on top of all the political stuff we already discussed.
Sure, and one thing to keep in mind related to that, and we see this on some circuit courts, right? So circuit courts, seniority matters for things like opinion assignment, right? So on circuit courts, cases are heard in panels of 3. The senior most judge in active service is the one who decides who writes the opinion in a case, and that can matter. And there are a few judges on some of the circuit courts who are very senior, who it's pretty clear don't want to give up that power. Now we may think that's because they have an inflated sense of their own worth or their own opinion writing, whatever else, maybe. But and I'll just use one example. In the U.S. Court of Appeals for the Sixth Circuit, a judge who's eligible for senior status there is Karen Moore. She's 76. She was appointed in 1995 by President Clinton. She is, other than the chief judge of that court, the most senior judge on that court. So unless she's on a panel with Chief Judge Sutton, she can be in the majority. If she's in the majority, decides who writes the opinion. She is also, I think it's fair to say, historically been viewed as the intellectual leader of the more liberal judges on that court. Right, that is to say, with the possible exception of a judge that was appointed by President Biden, who's Rachel Blumkatz, who's one of the most junior judges on that court. Judge Moore was considered to be the judge with the most intellectual firepower on that side of the court. Well, if you go from someone with that combination being very senior and being able to take an opinion that's going to reach a conservative result and write a really narrow opinion to really kind of minimize its effectiveness or influence, or someone who is trying to write a more progressive opinion by trying to evade or get around Supreme Court opinions, the ability to do that may be significantly reduced were she to step down, and that's arguable. I mean, I don't know. I don't have any direct knowledge of this, but certainly one could speculate that one reason she did not take senior status under the Biden administration would be because she was concerned about that impact. And that certainly happens. You certainly see judges in that situation. And there's currently a fight on the U.S. Court of Appeals for the Federal Claims involving a Judge Pauline Newman, who's 98, where her colleagues on the court are alleging that she's no longer capable of performing the job and have effectively tried to, for all practical purposes, remove her. And there's been litigation over that because 98's pretty old for a judge.
Yeah,
pretty old for anybody, for anything.
Right.
But
sure. I mean, impressive, but yeah, because should you still be in that position at that age is I think as America has grappled with over the last 5-6 years here is an open question.
Yes,
right?
she's one of two. This is a fun fact that she's one of two sitting judges who was appointed by President Reagan in his first term. So she was appointed in February of 1984. So she's been on the court for, oh gosh.
What is that now? Is it 41 years?
Yeah.
It just doesn't seem like
41 years of service.
long, but,
Right. The rule is, the rule for being eligible is the so-called rule of 80. So that your years of service plus years past 65 have to combine to 80. And she passed
but
that.
There's nothing that forces you to retire or take senior status, right?
No. So the litigation in her situation is really over whether the other judges on your court can conclude that no, it's time to go,
right.
or you're not up for it anymore. And
right, and that's usually the case with a lot of the people in positions of power in our government. Is there's not necessarily a mandatory retirement age for. There may be in things like military service, but not in
some
public
states.
service.
Some states have that. So in Ohio, where I lived for 25 years, judges are elected, and you can't run for re-election as a judge once you've reached 70.
Well, maybe some of the states have gotten it right. Yeah. I don't know, but
so you can kind of play games about like trying to get elected when you're 69 or something. But when you turn 70, you're in your last term.
But we don't have anything like that at the federal level, and so that leads to some of these some of what we're discussing now with the lack of vacancies. So, with all that said, right, it appears that the president is going to have less of an ability to shape the federal courts this time around. At least it's going to be harder than maybe we would have thought going in. So I guess the question becomes, I remember early on after the election that we did podcasts and wrote some pieces where we looked at like what are the things that are where Donald Trump is most likely to have the longest lasting impact or the biggest impact as president when it comes to gun policy. And we concluded it was the courts, right? Because courts are lifetime appointments. They'll likely have the opportunity to change the balance of some of these appeals courts. And as you mentioned, it does look like the Third Circuit, he will shift the balance slightly there. But I don't know, this maybe is a good time to reevaluate those ideas, because the thought was as well that, he didn't do a lot on the administrative front that gun rights advocates were happy with in the first term. Legislation seemed, even with Republican control of the House and Senate, wasn't at the margins that you need to pass major gun legislation, was the assumption coming in. But those two, we've seen actually more progress, I think, than people may have expected, and certainly than we predicted, with more action on the administrative front, more than just rolling back some of Biden administration's initiatives. And also actual some legislation where they cut the tax associated with firearms suppressors and short barrel shotguns and rifles. So now it's seeming that the judicial appointments are kind of stalled here, and there may not be a lot of opportunity to shift balance of the various circuit courts, especially before the midterms, where Republicans at least should have some fear of losing control of the Senate. Looking at the polling, I don't know. What do you think? Should we reevaluate what the potential long-term impact of the Trump administration is on gun policy over this stuff?
Well, I'm not sure. I mean, for a couple of reasons. One, we're still seeing the effect of the first term on gun policy. There was just a decision this week on whether or not individuals who have medical marijuana cards lose their gun rights, and marijuana users in the 11th Circuit Court of Appeals. Very important case, and we may have even talked about that before. I mean, a big anomaly in the way marijuana is dealt with legally at the current time is that um, using marijuana consistent with state law can make you ineligible for federal purposes of purchasing a firearm, which seems to a lot of people backwards, especially since you're not, talking about violent felonies and whatever else. So the impact on the judiciary, I think we're still seeing, right? We're still seeing in various circuits, the Ninth especially. We will continue to see that effect in the Supreme Court, and so in some respects, we have not fully seen the impact of the first Trump administration on gun policy through the courts. We've not seen the fulfillment of that yet, or we've not seen the full extent of that yet, because that's still ongoing. On the administrative front, I mean, I think, there are things that the administration can do, but there are limits there as well, because those actions are subject to judicial review and have to be consistent with the statutes that are on the books. And as we've seen on things like whether we're talking about ghost guns or bump stocks or whatever else, there's really a limit to what the executive branch is going to do administratively. There's a limit to what it can do unilaterally. And the more aggressive things it might try to do have to withstand judicial review. And I will just note, for at least some of this stuff, a lot of the regulatory sorts of things will end up going through the U.S. Court of Appeals for the D.C. Circuit, which is not a particularly gun-friendly circuit, and is not likely to be anytime soon. It has a 7-4 balance, 7 judges appointed by Democratic presidents, 4 by Republican presidents, and those Democratic appointees are pretty liberal, pretty skeptical of gun rights. So, I do think that while the second term is likely to have less of an impact on gun policy through the courts than the first term did, I'm not sure it's going to have as big an administrative impact as we might, as one would hope, or even that it might act as if it will, because that stuff has to actually make it through the courts, has to be legally defensible. The other
plus administratively, a new administration comes in and can just undo most of that's a bulk of what the Trump administration is doing now is undoing the previous administration's administrative gun policy changes.
Absolutely. And then it's also important to remember that, if one is focusing on this particular issue, that's compared to what, right? So the Trump administration's ability to move the needle further in the courts this term is reduced, and we've been talking about that. But it's certainly possible that had Vice President Harris been elected, that some of the vacancies that even though it's a small number, the number of vacancies that Trump is getting to fill would have instead been filled by a Democratic president. So circuits like the third that are going to flip might not have flipped. Courts that might have been closer might have been pushed farther out of reach, in the sense of replacing older judges with younger judges, replacing them with judges that might be perhaps more progressive on certain sorts of questions. Because again, as we talked about a little bit, in the last 25 years or so, circuit court judges picked increasingly for their judicial philosophy and less because of political connections. And so the potential jurisprudential impact of each pick thereby is actually a little bit greater, because
right.
you're not just getting some person.
Yeah, there's not as many wild cards.
Right. And so that's worth keeping in mind. I mean, there are a bunch of seats that are there are a bunch of seats that will where the current occupants of those seats will become eligible for senior status over this term. About 14 or so Democratic nominees that will become eligible in between now and the end of 2028. And there are about 9 or 10 Republican appointees who will become eligible in that same period of time. even if those seats don't become available for President Trump, we don't know whether they would have become available for President Harris, and some of them might
Sure.
have. So,
and I guess as well, when you look at legislation, it's even with the somewhat surprising move to add the NFA, the National Firearms Act tax cut to reconciliation, something that I don't think people were necessarily predicting. It was an idea that was out there. We discussed it before it became, reality, but it wasn't something that was, I think, widely discussed, back in December 2024. Even with that happening, it's still fairly scant, the opportunities for new gun legislation at the federal level. And so I guess it seems like you would say that even with this diminished, I guess, ability to appoint federal judges and flip control of circuits, it's still in the long run going to be the most significant thing that the president does on gun policy.
I think so. Although, it may be that that's in part because it prevents backsliding than it does, much more. But my view on this generally is, as listeners know, Second Amendment jurisprudence is relatively young.
Right.
It really, yes, Heller was very significant, but it really wasn't until McDonald and then Bruin that their lower courts began to get meaningful guidance that they had to take the Second Amendment seriously. We are still working through what that means. And while there are certainly going to be cases where various gun laws get upheld. Those laws that folks would identify as being particularly vulnerable, a lot of those are still on the books. A lot of the litigation relating to those is still going on, and it takes some time. And the composition of the courts certainly matters for those cases being able, to be resolved correctly.
And I would also note too, or I guess one of the thoughts here, the questions here would be like, the going back to the potential reason that some of these, especially Republican judges, aren't retiring or taking senior status, relating to Bove and sort of what he might represent as the second term approach to judicial appointments. I mean, that's a risk not just for these Republican judges and their potential concerns. They haven't spoken up and said this, right? So it's speculation, but there are potential concerns about their predecessor, that they're the people who come after their successors. And this is also a potential problem for Second Amendment advocates, because I don't know that Bove doesn't have a track record on gun policy. We don't know necessarily what his judicial philosophy on the Second Amendment is. And if there are more picks like that coming down, then your more picks that are like the first term, where they were more uniformly originalist on the Second Amendment, that's a risk too. Like, it could go back to the days where Republican appointees would rule against Second Amendment protections. It's not that long ago.
Very much so. I mean, I have no idea how Judge Bove is going to approach virtually any case. I mean, I know he has.
I guess we'll find out soon, right?
Well, we will. I assume he has experience as a in the criminal justice system, as both prosecutor and as a defense attorney. I don't. We don't.
He's never been a judge, so we don't have rulings.
Never been a judge, never been, other than his brief period in the Trump administration, never been in a position where one would expect legal philosophy and the like to have an influence on. And
he was only there for a couple months, and it came with a lot of controversy surrounding it.
Where sometimes, you have nominees that, they worked in the state attorney general's office. They've been involved in policy-related litigation, writing. They've done the sorts of things they've done. At least give you some sense of how they might think about legal questions. And in his case, I guess, I don't think we really know. Now, maybe he'll be a fine judge. As I've said before, I don't know him personally. I know what I read in the papers. I take some of that with a grain of salt, but to to me, it's a big question mark. And as we already noted, it's understandable why judges who don't know him either, and only know what they read in the papers and whatever, might also see that as a question mark.
Or Second Amendment activists as well.
Yeah. And
because I think it seems like, I feel like we're on the same page here as the idea of, it still appears that judicial appointments are going to likely be the most consequential long-term impact. Most consequential thing that President Trump does in his term on gun policy has the longest term impact, just because of the nature of our administrative changes and the dim possibility of further legislative changes, and the nature of lifetime appointments. Like, it's just, for most presidents, judicial appointments are going to be the most impactful long-term thing they do on gun policy. But we don't necessarily know the impact. We know what the impact was the first term, and it was one that judicial conservatives liked and Second Amendment advocates liked. And that's where as you went over, some of these appointments are pointing back towards that approach. And then you have this one appointment with Bove that points in a different direction. And I guess we'll have to see which one of those wins out in the end. But it feels like perhaps some of these judges don't want to find out, and are more content to wait.
It certainly looks that way. And as I said, I've certainly heard comments to that effect from folks on the bench that they think that has an effect, at least on the margin, right? That, it's not affecting every judge's decision, but, if you're talking about 24 judges that are eligible for senior status, is that affecting the views of 4 or 5 of them? Maybe. And if it's affecting 4 or 5, well, that's as many circuit court vacancies as there are right now, right? So if it's affecting only 4 or 5 judges, that would double the number of vacancies that the president has to fill on circuit courts at the current moment.
Well, this has been a really interesting roundup of where things are at. A good check-in, I think, to kind of ground us as we move forward, and to look back at some of our early predictions on what would likely come of this second term. And I think we still are on the same basic path, but have to update with the current reality here. But I appreciate you joining us and giving us your insight and all this information. I think it was a really good way of getting further understanding of what's going on with the courts from a macro perspective, especially with appointments. And look, if people want to follow your writing or they want to follow your work, well, where can they do that?
Well, I blog at the Volokh Conspiracy, which is a legal blog that is hosted by Reason.com, although we are editorially independent. It's kind of a center-right group of mostly law professors with libertarian leanings that write about a range of subjects. And then on Twitter, I am at jadler1969, and I have a Blue Sky account that has a similar name, but I'm more active on Twitter, or X, I guess I'm supposed to say.
Yes, the X, the everything app.
So those are the easiest places. I'm a columnist for Civitas Outlook, published by the Civitas Institute out of the University of Texas, although I tend to blog about that kind of stuff when it appears as well. So the Volokh Conspiracy is probably the easiest one-stop shopping for that kind of thing.
Wonderful. All right. Well, we appreciate you joining us, and we'll have to have you back on again in the future to give us another update as these things progress.
Sounds good.
And we can maybe divine which way the president has decided, which path he's decided to take on these appointments as they roll in. But that's all we've got for you guys this week. You can head over to reload.com right now if you want to sign up for our free weekly newsletter or buy a membership to get exclusive access to hundreds of pieces of analysis and reporting you won't find anywhere else, as well as early access to this here podcast. But that's all we've got for now. We will see you guys again real soon.